That process that I described happened in 19 seconds. From the point in time that the two rafts met until ultimately the conveyor stopped, happened in 19 seconds.
Wow, that's incredible.
Like any prosecution in criminal courts, the charges are laid and the defendant in that case has to decide whether it pleads guilty or not guilty to the events. And as we now know, they pleaded guilty and were fined $3.6 million for those three failures. My view is this was a preventable tragedy. So, the question becomes then, so was it foreseeable and what could have, should have been done? That day was absolutely the toughest day for me as a prosecutor, but I don't know that anybody but those sitting in the courtroom that day could understand the feeling and really get a sense of the loss suffered by the families of those victims.
All right, welcome to this episode of The Art of Safety Leadership. We've got an awesome guest for this episode, respected legal expert, former work health and safety prosecutor, and real leader in the formation and pathway for the regulatory side of work health and safety here in Australia, Aaron Guilfoyle. Welcome to the episode.
Thanks very much for having me on, Nathan.
Great to have you.
Thanks.
Now, you've had a cracking career. You've been some pretty interesting things you've seen over the years. Do you want to just give us a little bit of a background as to, I suppose, your career pathway, how it all started, and kind of a bit of a summary of where you've been, what you've done?
Yeah, absolutely. I work now almost predominantly in safety, but I feel like so many people who find themselves ending up working exclusively in safety didn't set out to do that. Yeah. I started my legal career as a federal prosecutor. I answered an ad in the paper, as you did back then, for a 10-week contract to fill in for somebody looking after mainly welfare prosecutions for the federal government for that short period. And I left there 18 years later.
Wow.
When I was appointed by the state government to the work health and safety prosecutor role that you mentioned in the intro. But during the course of that time, this is kind of, I guess, part of the story of how I fell into safety. I prosecuted a wide range of things, but had a particular focus at different parts of my prosecuting career in the federal government on safety and other regulatory areas, and very quickly came to love doing it. It presents particular challenges. So not so much work health and safety, but things that looked and felt a bit like it, like maritime safety, like civil aviation safety, and some other regulatory areas. And that led, as I said, to being appointed the prosecutor, the inaugural independent work health and safety prosecutor in Queensland, a role I was attracted to in part because it meant that I was going to focus on and hopefully develop a real expertise or a greater expertise in this area rather than what I'd been doing, which was, prosecuting a lot of different crime over kind of the first 20 years of my career. So I performed that role then as the chief executive of that office for 3 years. And 3 years into my term there, accepted an offer to establish the safety and regulatory practice at McDonald's Law, my current firm. And so then took what I'd been doing on one side of the courtroom or one side of the boardroom, the business table, to the other side, with a caveat that we still advise government and we still advise on prosecutions. But a big part of our practice now is taking those things that I learnt over all of those years, looking at it from one side of the table and talking to business and workers and C-suite within business about how we think they go about not finding themselves up in that other place.
I mean, it's an absolutely fascinating lens, because I think it's a perspective that most people out there listening to this wouldn't have expertise in, by and large. Most of us don't know a 20-plus year experience prosecutor in the industry. And so we're going to really dive into some of those kind of themes today in terms of particularly some of those key cases that you've been heavily involved in leading, in terms of the Dreamworld prosecution, for example, after that tragedy, kind of get a real kind of sense of, I suppose, the process and what's involved. Because ideally, if people out there can take a bit of a learning or a lesson or a gold nugget out of some of the experiences and help prepare their business better before an event occurs, and ideally prevent an event occurring, obviously. But invariably we're talking about risk and things do happen. And there's a great opportunity to mitigate losses if people have the opportunity to have some perspective on the sorts of things you've been involved in over such a long period of time. So I think it's a really interesting topic and an unusual topic for probably most listeners out there.
Yeah, absolutely. It's been a fascinating journey for me and my team in the last 3 years advising. As a career prosecutor, you are used to people, as a rule, telling you nothing, trying to tell you nothing. It's kind of part of the defence strategy, I suppose, in part when things go wrong. And so, I've been fascinated to see what it's like in the last 3 years, and then kind of bring the two together, you know, what business has been doing, what we think business should be doing. Yep.
No, that's brilliant. So one of the topics we're going to kind of dive into is something you've got incredible expertise in, and which is industrial manslaughter. Do you want to give us a bit of a background as to 20 plus years when you were sort of starting out in this field? Over the time, it's obviously evolved and developed quite a bit. Do you want to give us a bit of a summary of kind of industrial manslaughter, where it sort of has started, where it's kind of at now, and kind of the direction of travel it's taking us?
Yeah, absolutely. Industrial manslaughter is still, in the Australian context, a pretty new thing.
Yep.
Yeah,
was it 2017-ish?
2017 in Queensland.
Yep.
Queensland legislated industrial manslaughter in 2017 as a result of the review into work health and safety regulation, which followed the Dreamworld tragedy, the Eagle Farm racecourse tragedy. And, only 8 years ago in 2017, Queensland became the second jurisdiction to have industrial manslaughter, or the first to have it in its work health and safety legislation. And then we saw a lot happen between 2017 and now. And I think that perhaps it could have gone another way to the way it has, because of what I saw when I was first appointed as the work health and safety prosecutor in 2019, an absolute resistance to the legislation of work health and safety, or corporate or industrial manslaughter across Australia. When I was appointed in 2019, industrial manslaughter had been on the books in Queensland for about 2 years, maybe 18 months. And with that unique position as an independent prosecutor in Australia, still the only one of its kind, I was asked for the next year or two, when I was speaking around the country, well, what do you think about this thing? Probably in part, do we need it? And you've got it. What's going to happen with it? As an independent prosecutor, I really avoided weighing into the debate about do we need it. I have a view about it, about its utility. But at the time said, well, our role as prosecutors is to use the thing that's been given
the instruments.
to us. Yeah, that's right. And from the outset of my time in that role, which is leading a team of prosecutors, and day in, day out, they're looking at serious incidents for the most part, and a lot of those involve fatalities. And they're making assessments about, well, does this thing which happened, which led to this fatality, does it lead to culpability for industrial manslaughter? And they're making recommendations. And so very early on in that role, BAU is looking at all of these recommendations on these incidents. And it seemed apparent to me that the bar to successfully prosecuting industrial manslaughter was probably not as high as I think some others thought it might be. Easy, I suppose, in a sense, to say that you think people are going to be prosecuted for an offence when you are the sole decision maker for that to happen. But my genuine view was I think some of these things that have been happening at least in Queensland, will be caught by this new legislation. And that's what I was saying to business. And in fact, that led to the first industrial manslaughter prosecution in Australia being laid in Queensland. And then, of course, one doesn't know whether that's had a true flow-on effect. What we do know is what happened. And as we sit here now, every jurisdiction in Australia, including the Commonwealth, now has a version of it. As I said earlier, I think it's still in its younger days because we've seen jurisdictions who have not yet charged it, and admittedly, some of them haven't had it for very long. But I think if you look at the history of the prosecutions that have been laid, the lion's share of them have led to a conviction. So I think it answers that question that people had. Do you think industrial manslaughter will be charged? Do you think it will be possible for people to be convicted of it? I think that the only bit to be seen now is our prosecution decision makers in all of the jurisdictions across Australia, are they going to prosecute it? Because I think the short history we've had shows it's prosecutable, if that's a word.
The test is there. So that's really interesting. So if we just think about we've got some listeners out there, CEOs, board directors, senior safety professionals, and I'm sure a lot of them aren't legal experts. Do you want to talk a little bit about, or confirm I've got this right for people out there? So when we talk about industrial manslaughter, we're talking about a criminal charge, So on the individual.
Individuals and businesses. So both. The law considers a person to be an individual. It considers a person to be a body corporate like a company. And both of those are subject to it.
Which is separate and in addition to, I suppose, the civil regulatory kind of process, Health and Safety at Work Act, in terms of PCB obligations, due diligence obligations, those sorts of factors, or is that?
It sits in the Australian jurisdictions in the Work Health and Safety, Occupational Health and Safety Acts. Some of the legislation requires proof of a breach of a duty in the Act. Some, like Queensland's, don't strictly require it. The things which lead to its prosecution, the acts or the failures to act, are the things which were traditionally and which continued to be prosecuted under the various Work Health Safety, Occupational Health and Safety Acts. The added elements are, one, that act or omission substantially contributes to a fatality, and then, depending on the jurisdiction that you're in, an element of negligence or recklessness. And that's largely what it was designed to capture, not the kind of strict liability, no fault element breaches of the Act which had been prosecuted for a long time. But what about if the falling short is more than that? Well, what about if, to use or to paraphrase the test for gross or criminal negligence, the conduct, that act or omission, fell well short of the standard that was expected, or in the recklessness context, a person within the business or collectively the business knew about a risk and decided to proceed indifferent to the risk, and that led to ultimately a tragic fatality.
That's really interesting. So given your sort of experience prior to becoming, I suppose, an independent prosecutor, and having that provision available to you, or that instrument available to you, did you ever kind of retrospectively kind of look at cases that had, or incidents that had happened sort of in the rearview mirror and kind of thought, actually, that would be a sitting duck for this type of legislation to play out, or?
Yeah, exactly, Nathan. That's what we were doing in the early days of the formation of this independent office, is looking at things which had gone in the past and were still before the courts. We're looking at those factual scenarios, and we're looking at the conduct said to constitute some lesser offence. And we're sitting there thinking, well, hindsight's wonderful, of course. The things, at a different time period, it's already been charged. But yes, I think that looks like it satisfies the elements of this new offence, and that's why we had this sense that there were going to be more matters which were caught by this new industrial manslaughter offence.
Interesting. So some of the, I suppose, then some of the, call them war stories. It's not necessarily an elegant term, but what are some of the kind of, without necessarily naming and shaming, but what are some of the really poor practices you've seen in some of these cases that you just kind of either, and I'm interested to explore how they make you feel when you're sort of exercising your role as a prosecutor. What are some of the bad examples, I suppose, that you've seen in your travels?
Yeah, I suppose one thing to note about it when you're performing this role as a prosecutor and you're deciding, does the evidence of what happened fit a particular offence, that it's often not the gravity of the outcome, the extent of the tragedy, which speaks to the culpability, which speaks to how much, if at all, a business or an individual within a business fell short of fulfilling their duty.
Yep.
I think it's a particular challenge for people working in this space, particularly when there's an expectation from whole of government, there's an expectation from the public about certain outcomes that sometimes it's not the extent or the gravity of the outcome, including a tragic loss of life, which kind of speaks to whether somebody got it wrong, and if so, how much they got it wrong. You see when you're looking at incidents which involve near misses, so no injury, no fatality, fortunately, that the culpability is greater than it is when sometimes we've got loss or multiple loss of life.
Yes.
And that can be difficult as a prosecution decision maker because people have this expectation and you can't meet their expectation because when you pull it apart, maybe you can't identify that somebody got something wrong. Maybe somebody didn't get anything wrong, or if they did get something wrong, it's not the kind of wrong which leads to an industrial manslaughter prosecution. So just want to make that point that, it's not always the outcome which kind of dictates whether or not it might lead to an industrial or corporate manslaughter prosecution. It's hard not to conclude, having looked at, in the space of 3 years, literally hundreds of serious incidents, most of them fatalities, most of them serious injuries,
DPD,
a lot of them, fatalities, that almost all of them are not preventable. And, when you're dealing with the families of victims, you're dealing day in, day out with people who have lost their parents, they've lost their partners, they've lost their children. It's frustrating. Yeah. It's frustrating. You can't turn back the clock for them. And as I said, sometimes you can't achieve the prosecution outcome for them that they want or that they think they want for a lack of evidence, or in fact because in that particular scenario somebody didn't do the thing that was that culpable thing which constitutes industrial manslaughter. What we did see was far too many examples of, and perhaps surprising by 2019, 2020, only within the last 5 or 6 years, of people doing things which clearly fell well short of what was expected by workers, what was expected by other stakeholders, what was expected by members of the public. And then this other category of people very clearly being cognizant of the risk and deciding sometimes to put themselves at risk, business leaders, but usually deciding to put other their workers at risk, for a range of motives. And sometimes those motives are cost, sometimes they're not. Sometimes it's just inconvenience. Probably describe it as a sense of frustration that you certainly can't turn back the clock, but sometimes you can't do more when there's an expectation from stakeholders that you do something.
Yeah, I mean, especially the Dreamworld case, as an example, huge public interest at the time, and people wanting accountability. So you got that sort of weighing on you as well, and wanting to exercise accountability, right? That's a pretty important part of the role. But equally, having to establish and look at the facts relative to what the standard says, the legal kind of standard says, and then make decisions based on that, which in that case was an outcome. Yeah,
that's right. That's a really great example of that expectation that I spoke about. Yeah. That was a matter in which members of the public with no ties to the case were writing letting known what their expectations were, based largely on the outcome, but based also on findings in another forum, which may or may not have been relevant to the consideration of my office about who should be charged, and if so, what should they be charged with, and all of that being done in a context where you knew that there would be very significant media coverage of it, but ensuring that notwithstanding stakeholder expectation, notwithstanding the coverage that we knew it was going to get, you still did that job of scrutinising the evidence to decide who, if anybody, got something wrong.
And in terms of those different kind of processes, you talk about things like the coronial inquiry, outcomes of that, recommendations, etc., as compared to the, I suppose, industrial manslaughter consideration or other processes, right? Because they're testing different things and trying to achieve a different outcome to solve a certain problem, right?
Yeah, that's right. The coronial process is trying to unpack the best it can what went wrong and to make recommendations so that that thing doesn't go wrong again. It applies different tests. It has different powers to the criminal courts where the work health and safety offences were, if any, were going to be tried. But because of the sequence that it was done there and which it's sometimes done, the public knows a lot about it. The public know a lot about purported failures and expect an outcome because of that, and expect an outcome because of the tragic outcome from the event itself.
Yeah, and I suppose in the modern environment, you've got misinformation, disinformation, social media, firing stuff around, journalists, trying to create news that people want to pay money to read, all that sort of stuff. And so, being able to just kind of put all that to one side and just, establish the facts, acknowledge the public interest, and just, stick to the course, I suppose, is the challenge, right?
Yeah, exactly.
So whether it be you're the CEO of Dreamworld or any other business for that matter, or the board chair or the director of health and safety, and there's a huge amount of work that happens around the world on any given day, and things happen. And if you're in one of those kind of key roles inside a business, board chair, CEO, director of safety, and the call comes in, one of our people have lost their life. What are the immediate considerations for people in those roles that they need to be thinking about? Do you think, in terms of what do they do? What could they expect to have happen? So I think that's a really interesting insight, and it's an insight you'd want sort of people to learn without having to go through the actual event at all, right?
Yeah, that's right. One of the things that has struck me in medium-sized, large-size business in the last 3.5 years in the private sector advising business is that people don't really people don't step through or role play
what would it look like.
Yeah, what's that like? I think to the extent that they should, and in 2025, people are certainly talking about it at board level, and I think if nobody can ever truly judge the deterrent value of an offence like industrial manslaughter, my experience has very much been that people sitting, the C-suite and the non-executive directors sitting in the boardroom, they're very conscious about the potential for these penalties when that call comes in. Yeah, I think it both drives behaviour, including in improvement within business. Certainly, that's what I've seen. But it absolutely drives the response when that phone call comes in. Business leaders know now that in every jurisdiction it's on the table. So there's, of course, the feeling which accompanies that tragic loss of life in any event. And added to that now, you've got this fear of, well, we know that this offence is out there, and what's that mean for us? That's what safety and regulatory lawyers do, is give advice because on how to respond to that, because we are in the position of having been through it a lot of times already, and I think that whoever it is that is brought in to assist is better placed to do it, or at least the business benefits from that because you're one step removed, irrespective of your experience. It's what struck me assisting and advising clients post that most tragic of outcome, is the human element. You go into the workplace and it's absolutely palpable. It affects every single person, and it affects them in a significant way, irrespective of your seniority. So you kind of have to deal with that
kind
grief
of acute, right there sort of stuff.
Yeah, that's right. And there are a lot of things to be done, and you have to do those things in this new context where there are unprecedented fines on the table. And there is in my view at least, a real risk of sentences of imprisonment, contingent mostly on what's happened within the business prior to the incident, but also depending on what advice the business gets and how it responds in the aftermath.
So that's a really interesting point, because I think a lot of people wouldn't necessarily consider that, because you kind of think an event happens, a tragedy happens. Obviously, there's going to be a rule to run over that business in terms of how they've managed risk, how the whole 9 yards. But actually, what they do in the immediate aftermath of the incident, you're saying, is also a contributing factor into how that's ultimately evaluated. Yeah,
that's right. We say, well, there's risk which arises from those things which happened before. But a failure to get that kind of independent advice from safety lawyers, from independent safety consultants who, again, are one step removed from the business and can bring that independence and impartiality, is very critical to reducing or not increasing your risk profile after the incident. What happens sometimes is in the heat of the moment, bearing in mind, you've got inspectors, investigators from the regulator, quite often police are involved. People do and say things which sometimes are not even true, but they feel compelled to give a response, and they start talking about, that stuff. Well, what were our policies and procedures? What had we done to assess this particular risk? What were our controls? And we've seen examples where things are said where people are trying to do their best. People, by nature, at least the people I've advised, want to help. And helping is talking and giving information. But everybody, particularly in the C-suite's got an obligation to protect the business
as well as the people.
That's right. And it's a really unique environment where getting the right advice is very much key to whether it's a reduction in the risk profile or not increasing the risk profile of the business after the incident.
Because it's a really fascinating insight, because you're the CEO of a business, or the board chair, or director of safety, those sorts of roles. You have a major catastrophic incident happens. You've immediately got shareholder needs, you've got regulatory needs, you've got your people, your actual workforce and their families' needs, kind of that immediate sort of emotional well-being diffusing type issue. You've got media, you've got a lot going on. What would be your kind of any gold dust or gold nuggets around, if you were in that position, evaluating and just weighing up how you manage the needs of the people at a really human level versus, as you rightly point out, like protecting the business and mitigating further losses post-event?
Yeah, I think to mitigate legal risk, the thing that I do day in, day out, you're never going to avoid the substance of all of those things. I think if you're a good business will help its people. Good business will help the families of those people who are also impacted by the business. They'll assist with the investigation by police or investigation by a regulator to the extent they can. I think what becomes important then is, well, we accept we're going to do those things. The substance might not change so much, but what's the form of what we're going to do? What's our plan for how we're going to do these things in a way which protects the business? We see, of course, we talk about the savings to business from good safety compliance, absent an incident, we talk about that all the time these days, there are absolutely savings to the business based on the form of all those things that are done post-incident. And you can see it from businesses which are ASX listed and have had fatality incidents. You can track the share price. And that's not to say that in any way those businesses are not concerned about their people. They absolutely are. We see that. It's just a cold, hard fact that you also have to protect the interests of other stakeholders in the way you respond to this tragic thing.
So it sounds like a good strategy would possibly be have a bit of a learned team. You know, obviously someone with your sorts of skills from a legal and regulatory perspective to kind of advise and just make sure that there's kind of someone on the bat phone ready to go to support that type of that part of it, but also someone to, you know, maybe people and culture type person around making sure the right support's been wrapped around your people, their families, the family of the affected people involved in an incident, the right sort of people with the right messaging going to your shareholders, your kind of core stakeholders, board, kind of just really, because that's a lot for one person to try and stay on top of, and having maybe a bit of a definition of who those people are before an incident happens is a really good idea, right? Yeah,
that's right. And I think even going so far as to step through
pre-mortem.
That's right. Step through what that's going to look like. How let's conduct an exercise where we draw all these people together because, look, the activity's frantic, particularly when it's high profile and it's in the media. The media are calling constantly, asking for somebody to say something. So who's going to control that? There's if there's an injured or fatally injured worker, there's their family, there are your whole workforce, then there are the regulator, the police. There's just a lot of moving components. So I think it's a case of having a plan, having the right people as part of that plan, and then in fact having a go at it, because my advice to business is you'll have a safety incident. If you haven't had one, you'll have one. It'll be a question of when it happens and what's the gravity of it, and then how are you going to respond when it does happen.
All right, so we're going to move into the next part of this episode. It's to do a bit of a deep dive on a really tragic incident that we've touched on lightly earlier in the episode. And it happened on the 25th of October 2016, and it was a catastrophic incident that occurred at the Dreamworld theme park here in Queensland, Australia, and it resulted in the death of 4 people: Cindy Lowe, Kate Goodchild, Luke Dorset, and Ruzi Argi, and it was on the Thunder River Rapids ride. The incident remains one of the most tragic amusement park disasters in Australian history, and had significant legal, regulatory and reputational consequences for Dreamworld and its parent company, Ardent Leisure. So, well-known incident. A lot of people would have had a lens on it. Before we kind of dive into it, where were you when you heard about it? What were you doing? What role were you in? Because it was before you went into the independent prosecutor role, right?
Yeah, that's right. So I was at the time an assistant director with the Commonwealth DPP, and what I recall is the shock. I recall the extent of the coverage. The thing about the Dreamworld incident is that it's been the most iconic Australian theme park since it opened.
Yes.
And I think that it grabbed the attention of the nation, not just because of the extent of the tragedy with 4 lives lost, but that tragedy could happen at that place where so much
happiness
of us, that's right, so many of us had been, and where I think certainly in the Australian context, all of those people hearing the story, all of the members of the public who are listening to the media coverage didn't expect anything of that kind to happen. When workers go to a lot of workplaces, high-risk industries, manufacturing, construction, warehousing, people know that there are risks because they're spoken about. There's hazard ID and there's risk assessments, and people know what to do to keep themselves out of harm's way. My assessment of it back from the time that it happened was members of the public in Australia at a theme park are unsuspecting.
Yep.
They don't think, at least my take on it was, they don't think that they might be exposed to a risk of injury, and certainly not to the risk of a fatal injury. So, I recall being shocked that it could happen. Of course, there was immense media coverage. I guess it was a bit of disbelief is what I recall.
Yeah. So do you want to talk us through maybe kind of fundamentally kind of what actually occurred on the ride that led to the fatalities, and kind of we'll sort of unpack it a little bit from that?
Yeah, sure. So I became involved in the matter not until 2020. In 2020, the coroner released his findings.
Yep.
The matter was then, by then I was the independent prosecutor in Queensland, and the Director General referred the matter to my office to scrutinise a brief of evidence which had been there for a long time but was awaiting the outcome of the coronial inquiry. What I now know from spending countless hours with that brief of evidence, ultimately leading to the successful prosecution of Dreamworld's parent company, Ardent, is that I touched on it before. My view is this was a preventable tragedy. So the question becomes then that everyone was interested about, continues to be interested. So was it foreseeable, and what could have, should have been done? As to the facts of the incident, you mentioned it was on the Thunder River Rapids ride. It's a ride which had been at the park almost since its inception in the mid-'80s, and or since the park's opening in the mid-'80s. It was a fairly simple ride. It was a gravity-fed watercourse. Inflatable rafts that held 6 people went about a 450-metre watercourse. There were 2 large pumps which pumped water up to the top of the watercourse. In a load area, the rafts were released, and when they got to the end of the watercourse, a conveyor belt brought them back to the unload area. The rafts went into the load area. You compared with modern-day rides, really quite a basic ride, a ride that had been there for a long time, but it involved a conveyor. And we know about, if you work in health and safety, the risks from people interacting with conveyors. Now, this happened to be a very unique workplace, but it was a workplace at which we now know people were interacting with a conveyor belt. A raft rather became stranded in the unload area. The raft became stranded because one of the 2 pumps failed. The pumps failed fairly frequently. Anybody who's ever owned a pump or serviced a pump knows it's a question of when will it fail, how often will it fail. The pump failed. That led to a drop in the water level around the watercourse. The drop in the water level stranded the first raft, which had some passengers on it in the unload area. A second raft came up about a minute after that raft became stranded. The second raft met it at the top of the conveyor belt. Both of the rafts became inverted. The first raft, which was stranded for about a minute, fell back into place. It was stranded on a platform which had been built to provide support underneath the watercourse. The second raft stayed inverted, and as we now know, was drawn into a gap between that platform and the end of the conveyor belt. That process that I described happened in 19 seconds.
Wow.
So from the point in time that the 2 rafts met until ultimately the conveyor stopped happened in 19 seconds.
Wow, that's incredible.
What we know, of course, is that 4 of the passengers on board the raft tragically lost their lives from it being drawn into the gap. It seemed, at least to me at the time, that it was a bit of a miracle that the 2 children who were at the high end of the raft, which became inverted, managed to climb out to safety.
Yeah, a small positive in a pretty negative situation. So coming into that then so we know what happened. You've then come in, the case has been referred to you as the independent prosecutor. How do you, what's the consideration, I suppose, coming into that you think that you're looking at initially? You've got the evidence file sitting in there to read up on.
Yeah.
Talk us through that.
Look, there are a couple of things that weighed on my mind. One was this thing happened quite a long time ago.
Yes.
And all of the people impacted by it. And I say that because there were so many people impacted by it who weren't just the families of the victims.
Yeah.
Everyone who was close enough to that incident, other workers at the park, the operators on the ride, the first responders, the investigators, was impacted by this thing. So one of the things that we wanted to do was get to the point of a decision and an outcome, whatever the outcome was, as quickly as we could. So that required some resourcing. So we put all of the resources that had been made available to us on it to try and figure out what it was we were going to do. And then once we made a decision to commence a prosecution against Ardent, to get that to a conclusion as soon as we can. In terms of approach, though, I like to think I'd benefited from having been prosecuting a whole range of crime and some high-profile matters across the course of a couple of decades by then. And you have to tell yourself that you have to approach this thing the same way you would any other prosecution. The test's the same, and you've got a job to do. So in terms of process, it was about trying to do the same job that we always did, notwithstanding the thing I mentioned before, the expectation of a range of stakeholders and the media attention that the matter had.
Yep. So one of the questions I've got was, following the event, we had the coronial inquest, and the coronial inquest came up with some findings, I suppose, that looked at the lack of proper risk assessments, design flaws in the ride itself, training and operational gaps, a culture of prioritising guest experience and profitability over safety. And I think the coroner described Dreamworld safety systems at the time as rudimentary at best, and basically noted it was only a matter of time. How much reliance or can you place on that coming in? So you're the next process, right? So you're the next in line, so to speak. Is that content that you are able to use, or do you have to recalibrate all the facts from scratch?
Yeah, the latter, Nathan.
Okay.
So I didn't, until the matter had concluded, read the coroner's report.
Really?
We had evidence that was available to us. The coroner may have had different evidence available to him and had different tests to apply to the evidence that he had available to him. So we intentionally didn't look at it exactly. Yeah, that's right. The prosecution that my office commenced identified not dissimilar failures. Dreamworld's parent company Ardent was alleged to have failed in three areas. One was training and instruction of the ride operators. One was the design of the plant, and one was the method of work for the operators.
Yeah. And so working through that, so you've presumably landed on those sort of three things that you're really going to make the case for. What happens next? So you've looked at the evidence, you've identified, we think these are the three areas that we've found that we're going to argue that we think that they haven't met the standard. And then it's court time? Yeah,
that's right. Like any prosecution in criminal courts, that the charges are laid, and the defendant, in that case Ardent Leisure, has to decide whether it pleads guilty or not guilty to the events. And as we now know, they pleaded guilty and were fined $3.6 million for those three failures. The thing that struck me about safety, I suppose, right from the time I was appointed as the independent prosecutor, but then really came home to me, standing in court on the day of Ardent Leisure's sentence, is this is another criminal proceeding in the criminal courts. Of course, we see around the country hundreds every day, but there's this human element to it, and I probably didn't expect that
Yep.
when I didn't understand the weight or the gravity of it
Yep.
when I first accepted the appointment as the independent safety prosecutor. And I've explained it to people in this way. This is what distinguishes it. And as I say, it was really reinforced or driven home to me standing in court that day in the ardent leisure sentence, was any premature loss of life impacts the people who are around it, usually the family, really much the same way, irrespective of how there came to be a premature loss of life.
Yeah.
I've got a view that the prosecution of work health and safety offences was for some reason treated differently for a lot of years in Australia. Having been a career prosecutor up until that point in time, I'd seen courts impose serious penalties for a whole range of offences which certainly didn't have that tragic outcome, but perhaps didn't have the moral culpability associated with it as well. So to go back to what we were talking about earlier in the episode, these kind of new penalties and the utility of industrial manslaughter charges, I couldn't see why work health and safety offending hadn't been, in my view, punished to the extent that other offending, perhaps less serious, had for a long time. And then, being involved in a range of matters with fatal injuries involved, and then, ultimately the Dreamworld prosecution. It's this human element, this premature loss of life, which I think for business, kind of looking at the work we do now, until you've been through it, it's really hard to understand the gravity of it.
Yeah, absolutely. So presumably things like victim impact statements, are read out, and that, I suppose, makes it very real for everyone sitting in a room. For anyone out there who's ever experienced that, it really just sort of brings it home, doesn't it? Yeah,
that's right. I mentioned when a workplace has a fatality, it's palpable, that feeling when you first attend. I had spent, I've lost count of the number of times I'd been on my feet in court, appearing in sentences as a career prosecutor until that point in time. But that day was absolutely the toughest day for me as a prosecutor. You're there to perform an independent role and you have a job to do, but I don't know that anybody but those sitting in the courtroom that day could understand the feeling and really get a sense of the loss suffered by the families of those victims if you didn't hear them, if you weren't there to listen to their victim impact statements. Yeah, it's pretty powerful. You can feel it in your voice right now. Absolutely. Yeah. All right. I suppose if you had to, and I'm sure you've reflected a lot on that whole sequence of events and the outcomes and the closure of it at the end of the day. If you had to sort of boil it down into sort of 2 or 3 kind of gold nuggets or things that, key learnings, if you like, from the whole process, from your lens on it, what would be the couple of things that you would reflect on for people out there that would be relevant if you're a board member, board director, C-suite, maybe a director of safety, that they can learn from the Dreamworld case? I said earlier, it's a really unique workplace, right? But it's still a workplace nevertheless. And, my sense was that Australian theme parks had been very focused on safety. So when you analyse that incident, you ask exactly that question. Well, what happened and what are the takeaways from it? Because this is not an industry, and that was not a business which hadn't done a lot directed towards safety. Yep. We spend a lot of time now talking to boards, non-executive directors and C-suite about, well, what is it that we do, and it's that it might sound a little bit cliched, but you can always do more. Yes, yeah. That's what I take out of the ardent leisure prosecution, the Dreamworld tragedy. A lot of people had been paid to do work to assess safety on those rides. And as you mentioned, the coroner made findings about some risk assessments that hadn't been done, and those were allegations which were repeated in the prosecution that I brought. But that's not to say that a lot hadn't been done. And I think that the challenge for boards, particularly of big business, when there's so much on the table. Never, well, not in my lifetime at least, have we seen this cost of living crisis that we're seeing now and across the world, and that impacts the bottom line. There's a lot to do in business to protect the business, that thing we touched on earlier. So you have to make time in that context to do more. What does that more look like? It's in part resourcing. Business has to continue to find the resources for safety, and business leaders can't delegate perhaps as much of safety as they think they can. And that's not about going and doing the safety necessarily. In fact, I think sometimes that's a bit of a pitfall. But it's about understanding, if we put it back in the Dreamworld context, what are the critical risks in our business? Do we know what they are? Have we done enough to educate ourselves about what they are? And have we done enough to educate ourselves on what our business is doing to mitigate those risks? A space
Absolutely.
That you operate in all the time.
Yeah, I mean, I suppose it's I think maybe a challenge for directors out there, particularly directors more so than executives, is getting a degree of comfort, satisfaction around the depth they need to go to on that issue. Because at a helicopter view, it's this is what our business does, but actually, in the Dreamworld context, we're a theme park. We have some roller coasters and some rides. We have rides that have water pumps that can generate these types of risks to people, our customers, or our staff, or both. And here's actually what the critical risk work that's been done in response to that to ensure we mitigate it out systemically in the organisation. And I suspect there's probably a vast range of opinions for directors in and of themselves as to what level of depth of knowledge they need to go into in order to satisfy and meet their obligations.
Yeah. If I ask most directors when we give them advice about what due diligence compliance looks like, do you think this is a safe business? Almost always the answer is, yes, I do. And I don't find it difficult to start to unwind that belief. And I see that as part of my job in advising directors. And that in part is that sense because, a lot of them are professional directors. They're very experienced. They've spent a lot of time performing that role, often for a range of different businesses. And they want to be safe, and they're often being told that we're a safe business. But my question is, how much have you challenged that advice? And are you scrutinising what you've been given? Because sometimes the gaps are in fact in the data that you're being given. And perhaps you just haven't spent enough time to understand what the data's saying, and to do that thing, which I think is sometimes hard given the time available to boards, is challenge it and ask why there are gaps there and what's being done to address those gaps. But it's very much about, for me, learning more in a whole range of aspects. And as I said, I think if you ask a lot of directors, whether they think their business is safe, they say it is. And I think, if they want to improve safety in the business, they just have to get out and learn a bit more about those critical risks. And second, challenge what's being given to them when the gaps might be obvious on the face of the data.
So that's a great little tip, good little takeaway right there in terms of, have that curiosity is really what you're saying. Like, be curious. If you're a board director, you should know fundamentally what your business is doing and the sorts of activities that you're undertaking. It's pretty basic. but you should be kind of asking questions and really trying to satisfy yourself, see it in action, observe it, ask questions of your technical risk people you've got access to, safety professionals, etc., and keep asking them questions until you understand it. So I think there's definitely a challenge out there around a lot of board tables that I've seen, where a lot of board directors find this whole kind of risk domain a little bit confronting and a bit challenging, and probably not feeling confident that people understand the technical, and the discipline can get quite technical, and so I suppose the tip you've said there is keep asking questions until you feel comfortable that you understand.
Yeah, that's right. And then, with the pace of change, once you feel comfortable, come back in a little while and ask some more questions, because the environment within the business is going to have changed by then. I think with the pressures on boards, it's easy if you have done that extra piece, you've challenged what's being given to you, you've got some either improvement or a better level of insurance, or both, better level of assurance, or both. Go back and ask again in the next period. Have new hazards been introduced? Are there new cost pressures such that there's now a resourcing constraint which didn't exist when we got the assurance 6 months ago? So it's just a never-ending job. Come back and ask again.
How much, sort of building on that, you talked about sort of the environment in the business. How much, and I suppose there's maybe a perception out there, and I'm sure you'll correct me if I'm wrong, that the legal and regulatory side of it's very sort of almost black and white and quite sort of by design, sort of very specific. How much does culture play in a business, particularly a proactive culture of safety, and when an event does occur and the inevitable ruler gets run over a business and its people and its leadership? And when that happens, the folks running the rule over observe that actually there's a really proactive approach to safety. There's strong leadership on safety. There's a real commitment to it, and you can sort of see it and observe it in a business. Does that contribute to how that business may be ultimately measured or tested from a legal compliance perspective?
Yeah, I think it does, so it feeds into, well, what was the level of compliance? And yes, there's a view that it's black and white. I think it's very grey. Yep. I think in fact it's problematic to try and apply kind of a black and white rule to how you go about complying, for example, with due diligence obligations. Yep. I think what that looks like in every business is necessarily going absolutely. I mean, one of the things that I find interesting about safety law is the grey. That's why a lot of people get into the law, because it's full of grey. And that what that grey looks like in terms of culture and what your people do is there's often a decision to be made. This is what I see, at least, and I'm not a safety professional. I'm just a lawyer. But what I see is business, because of its culture, because of the safety leadership at the highest levels, which is more accustomed to, when it sits in the grey, making the safe decision over the not safe decision. Yep. It's usually a do we or don't we do it, and do we do it now or do we do it later? Yep. Yes, a CEO of a very large client asked me once, could he ban use of the word reasonably practicable within his business. It's a business with a $1 billion plus budget, and I said, look, probably not, but I get the point. If this is the culture led by that CEO in that place. If we can do it, and we can afford to do it, it's in the grey, and we've got a safer option, or the kind of let's leave it as it is for the moment. If we can stomach it budget-wise, let's do it. And that's not to say that we can't acknowledge or protect the interests of stakeholders like shareholders. But I think when you want to look and try and test culture in a business, that's what it looks like to me. It's that business in which people are kind of trying to do what that CEO wanted to do, and take away the legal described as an out sometimes. Well, it wasn't that we didn't have to do it because it wasn't reasonably practical, but we did it because we wanted to be safer. And we, it might have some consequence, but we can still at the end of the day afford to do it. So I think, culture from what I see advising business gives people, whether it's middle management or senior executive or people beneath them who are responsible for the doing, that ability to make the safer call in the grey area. And then, absolutely, when we advise boards and executives post an incident, I think you can very quickly get an idea of whether or not it was a business which was making those decisions, which had safety culture. So, then we're not looking at, well, is this a business which made itself safer, but is this a business which is liable for the thing which has happened? Does this business have a defence if somebody wants to make an allegation that they didn't do their part?
Yeah, interesting. In your unique view, Aaron, over a long period, long career in the legal profession, an expert in the work health and safety area, what are some things that you think the most senior safety professionals could be thinking about or doing to better support executive teams and organisations to protect them?
Yeah, I suppose first a caveat, that I'm a safety and regulatory lawyer and not a safety professional, but we certainly have a unique insight. We're brought in to look at gaps. We're brought in to look at gaps post a serious incident. And I think probably what stands out to me is kind of, hopefully the audience will excuse me if it's an oversimplification, that there are still safety leaders within the business who come into the boardroom. They present their safety report, whether it's good, bad, or somewhere in between. And they might be asked some questions. There might be some action items for them, and they step outside. Then there's the category within a business which understands that the safety leader has to have input into a lot of what the business does as BAU, particularly when we see now the trend in claims for failure to manage psychosocial hazards and risks. The number of those claims that they value the return to work time for injuries of those kinds. We say, and certainly not the first, that never before has HR, the people side of the business and the work health and safety side of the business had to work together. And I'm just not sure how that can happen if the safety leader doesn't have a seat at the table, beyond doing what we see sometimes, which is presenting, the safety report.
Operational sort of part of it.
Exactly, how are we being brought in to talk about strategy? Some of this strategy might save the business money in a range of ways. We need to be talking about what the costs of doing safety are, what if we do need to spend money on safety, what are the trade-offs in the business? That money's going to come from somewhere most of the time. So what are we going to do, to try and accommodate both of those things that the business needs? So, there might be, people with safety qualifications of a kind that I don't have that say that's a bit of an oversimplification. That's certainly how I see it. The takeaway for me is there's such an opportunity, not just to avoid all those things that we've been talking about, the most tragic of outcomes and the range of detriments, the range of things that go along when something like that happens. But pre-incident, how do we leverage safety to save money, to make money? I'd call it, having a seat at the strategy table.
Yep. And I think maybe one way, I don't think it's oversimplified at all. I think if I looked at it from a board or executive lens on it, and you think about how your organisation generates value, how it actually creates value, how it sustains that value over a long period of time, there's very, very few businesses out there where it's not the people that are your workforce that drive that value. doesn't whether we're making stuff or selling stuff or whatever, whether you're a tech company or making gadgets or whatever. There's that people are at the core of that value engine, which ultimately as the board or as the executive team, you're ultimately accountable for driving good outcomes in those areas. So why wouldn't health, safety, and well-being of your people be right at the core of your strategy? So fundamental to your value formula.
Yeah, that's right. And I think if you ask workers, do they think that this is a workplace where we're physically safe and we're psychologically safe? And they say yes. The productivity's better. This is a place that people are happy to turn up to and happy to work at. And I've probably not been working exclusively in safety for long enough to know whether kind of this change is a more recent one, but I certainly think it's where every business needs to go. That for all of those things we've discussed, safety leaders in the business need to perform a different role than they once did.
Yep, absolutely. So if we flip that around and we've looked at the safety leaders side of it, if we've looked at the boards, if you're out there, you're a board member out there listening to this, what are the signs and symptoms or the sort of little red flags that you might observe that you should be concerned about around the board table about whether or not the organisation is stepping up to the plate in the way it should around health, safety and well-being?
Yeah, a couple of things that I see, I've seen in recent years. One is we're doing too well.
Yep. Nothing to see here.
Yeah, one is we're doing too well, particularly in high-risk industries. I recall in my earlier days in the private sector speaking with a CEO about how we might be able to assist with advice, front-end advice to improve safety within the business. And they were certainly interested to have a chat about that and went and spoke with their head of health and safety, who came back and said, effectively, we're a safe business, so we don't need any help at the moment. That's one version of what I'm talking about. Everybody benefits from diversity. Everybody benefits from different opinions. Safety's no different. So continue to look at how you can get different people to assist you to look at your model and see if you can do better. But I describe it as for too often we're being told that we're doing well. We're not seeing what struck me is we spoke about it a few times in this podcast. The human element of safety. That safety leader has to be a person, and I think this is another reason why they need a seat at the top table. They have to be a person who is happy to say, I lead safety and we've got some problems in safety. Because that's how we're going to get improvement. Well, that's great. Thanks for telling us. What do you need to do better in safety? That's
a heck of a strong point. It's a reality check out there. I've heard, I won't name and shame them, but I've heard very prominent board directors when they're faced with a question of, do you understand how your organisation manages risk and what the risks are, and with the response, we've got a great CEO, and they're across it, and then you then ask the CEO, how are you going with this? Well, I've actually got a great health and safety professional, and so it's this kind of like passing the buck kind of mentality, not through necessarily ill intent, but maybe a lack of understanding and breaking down those governance and management layers and the check and balance that comes through those layers, how that can ultimately manifest itself out to the safety professional team saying everything's great.
Yeah.
Where's the challenge on that?
Look, kind of to round out this point, I've been told by people, when you get a few layers down in that anecdote, so what we see is that, in between where I sit in safety and the board, it's not unusual for me to be asked to take that out because it's going to expose the board to too much risk. Now, hopefully that kind of thing is happening less and less in this day and age. But I can guarantee it's still happening somewhere, that we need to protect C-suite, we need to protect. So, you ask the CEO, no, I've got a great safety manager. But what if it's being filtered to protect you? And have you asked that question? Have you said, I want to know everything. I want to know the bad stuff as well.
Warts and all.
Yeah. The other thing we see with big business in particular, consistently trying to give better reporting to the board, so getting the right things in there, getting more of the kinds of data that they need, better board education, them asking for more, them getting the more, then is, and this is a particular area of risk for C-suite and directors, not asking questions about the gaps when there's a very busy agenda, in a whole day of board meetings, because our job is just to scrutinise that part of it when we're asked to give advice on gaps within it, and we see minutes coming out of it, and we say, look, but there's, there's 4 key risks in safety identified here. But you ask for a top 3, and so they're highlighted there, but four's actually on an objective assessment, really risky. So it was there, and we look in the minutes, and it hasn't been asked about. Now, one of 2 things: we didn't appreciate that was something we needed to ask about, or we did ask about it, but we haven't minuted it. Now, the minuting of it might serve only to protect you post-incident, but we'd say, well,
still relevant.
That's what you should do. But in the first category, the question's just sometimes not asked. And then the third is probably still we see. And I know safety professionals have been talking about the issue for a lot longer than I've been working in the area. Still a focus on lag indicators.
Yes.
Just not quite yet at the point. And, my view has always been you need to know, in the same way that I've said, if you're getting too great a report, you need to be concerned about that. So too do you need to be concerned about the incident rate and the injury rate within your business. But they're not being fairly prominent in the report. The safety executive's view on what critical risks are, and however you want to report it to the board, whatever your process of auditing is, here's our assurance to you about what we're doing to mitigate those risks. Here's how we've tested it. Here's what our lead indicators are showing us. Not seeing that, if it's not front and center enough, probably the third thing that I'd say might be something about which you should be concerned.
Yep, nice. This issue you must have come across a lot through your role, and it's the ageless classic of paper-based safety versus sort of practice. How and there's especially nowadays with a lot of AI driving a lot of the paper-based generation. I'd say more and more companies probably got policies and procedures, documents that they didn't realise what they even said. And when an organisation does have an incident and those documents get placed under scrutiny, the company gets placed under scrutiny. Talk us through some of the factors involved with that.
What I'd say, Nathan, is post-incident, that thing being done on the ground not matching the paper is so obvious. One of the reasons it's so obvious is that work health safety regulators and their inspectors have got investigation powers of a kind that not even police do. People understand that by and large, police ask me questions, I don't have to answer them. That's not the way it works in safety world. Those powers are used day in, day out across Australia. And that means, particularly as investigators in those regimes get more and more experienced and better training, they're going to find out about what safety looked like on the ground. And, certainly we've given advice to business, which is using well-known systems. And this is, kind of back to that last topic about, this is at an operational level, but there's green ticks every time we go and audit, this project. Can that be right, that every month, every tick was green, and then the incident happens? The way it plays out, the inspector then comes and just starts asking, Nathan, what, this critical control here, fall from height 7 meters, this incident's happened. How long's that been missing? Well, it's 2 or 3 months. It's so obvious that it doesn't
line up.
Yeah, that's right. Yeah, that's really my message, that and why senior leaders need to test what they're being given, because you can understand with time pressures the temptation to accept the great report card.
Yep.
But if you go and talk to the teacher, like the regulator will post an incident, you might find out, it doesn't quite match the report card.
So that's a great takeaway for people out there if they're sitting around the board table or even the C-suite, they're being presented with some of this information, and it's just really checking and challenging it, really just to satisfy themselves that there's a bit more depth behind it, so they don't end up in that position where I'm sure plenty of board directors would say, well, I thought that was taken care of. It said in the report that the green tick was in the box.
Yeah, and here's the thing about legal risk, I think, in this day and age. The green, you go and ask workers, well, why is the green tick there? And there'll be a reason. Yeah. There'll be a reason. It could be a whole range of reasons, but there'll be a reason. And that thing that's being checked, you get to the bottom of it, it doesn't need to be checked. Yep. And, agreeing to do something to a regulator looks like it was reasonably practicable. You said you would do it, and you haven't done it. You decided it was a safety control. That looks like a breach to a safety regulator. So we constantly give advice that if you go and test that and you ask your workers why they're not doing it, you'll get a pretty useful answer. And it might be that you need a new control, or you just need to get rid of that control. That hazard and risk is actually not real on the ground.
Yep.
Yeah.
And you're setting yourself up for a fall if you've got a control that's not unnecessary, and therefore you're not probably paying enough attention to it. And then when the inevitable ruler gets run over the business, then you're going to be come up short.
Exactly.
So leading on to that, because that's sort of almost a bit of a due diligence type kind of component, what does officer due diligence really mean in practice, the way you sort of see it?
Yeah, it's a question that we're asked every time we go into a boardroom, and I certainly think that boards and C-suite are getting much better at understanding what it is. And a lot of people have spent a lot of time and energy to give their version on it, and I won't pretend that mine's much different. But my advice is that putting aside what language you use to choose to describe it, in the model law jurisdictions, all of them bar one in Australia, and the same, in a country like New Zealand, the job is to ensure the business complies with its obligations. Yep. You want to really understand what it is. Due diligence is the name that's given to it. It might be through the different limbs articulated in the legislation, the vehicle that gets you there. But I said earlier that the way you do that is going to be different in every business because of its uniqueness, and that has to be the focus. And I'm not always convinced that those in the C-suite and directors understand fully what the business has to do.
Yes.
And it kind of makes me wonder if due diligence is the vehicle, but compliance by the business is the end game. How do you get there? How do you get to the business being compliant if you don't have a pretty high level of knowledge about what the business, usually we're talking about big business in a company here, what the company's obligations are?
What does officer due diligence really mean in practice, and where do you see senior leaders often getting it a bit wrong? We're asked so often the first time we enter a boardroom, what would help us understand what this is? And I think, more than ever, people have in C-suite and directors have got an understanding of what that means. I think simplicity is the key. Yeah. If you consider that the ultimate obligation under the model law is to ensure the business complies, I think that trying to understand all of the language of due diligence compliance is a bit of a red herring. Yeah.
I think key is, we discussed earlier, the need for greater knowledge about the hazards and risks within a business at board level. That the key is to understanding what is it that our business needs to do. I spend a lot of time dissecting that and less time really trying to dissect the language of due diligence, because at the end of the day, if the business is compliant, are regulators far more likely to consider that you've complied with your due diligence obligation, which is the nexus between the two things.
There's a kind of interrelationship there, isn't there?
Yeah, that's right. So, what is it, having the best understanding you can about what the hazards and risks are in your business and how it is the business has to go about complying with those things. I really think that's the key to due diligence compliance. And a lot of people have spent a lot of time and energy dissecting the language of what due diligence is. I think that people generally end up at around the same point, which is you need to know about work health and safety generally. You need to know about hazards and risks in your business. You need to ensure that it's doing what it needs to do. And of course, that can be in itself, the topic of another hour of conversation. And then you need to verify. So you've been told that it's doing certain things. What's your verification of that? That's kind of, the way I explain the vehicle that I consider to be due diligence along the way to compliance by the business.
Nice. And it's presented in a way that's super practical. People can take that away and put that in their own context and apply it, which is what we want to see people doing out there. All right, we've had an awesome conversation. Been really, really interesting, a really unique perspective on things in the industry, Aaron. So thanks for what you brought to the table. Now I've got a couple of rapid fire questions, which we always ask all of our guests on the podcast, just to delve into. I suppose everyone's got a unique story and different DNA, and it's interesting to kind of unearth some of that. So the first one is you're obviously a real leader in your field. Which leader most inspires you, and why?
I had a mentor. I was fortunate to have a great mentor when I started in the law. He gave me my first job. My 10-week contract that turned into, that's right. And I very quickly decided that I wanted to be a leader of the kind that he was. So he's retired prosecutor now, Gary Davey. But he did two things. He was very dedicated to what it was that we were there to do, irrespective of the client. So, we've got a goal. The way we achieve it, we have to consider, all of our clients are trying to achieve something. We're here to assist them with it. So, a focus on the goal, but at the same time, an understanding of his people and an understanding about how to get the best out of his people, and things that took me a while to learn, like compassion, to absolutely understand your clients and achieve for them what they need, but understand you're probably not going to do it if you don't understand your people and you're not a compassionate leader. Without looking after your people, you're not going to achieve this thing, and that thing's really the only reason that we're here. We're here to achieve that goal.
Shout out to Gary. Sounds like a pretty inspirational person in your life. Yeah,
absolutely.
It's pretty cool. What's the best piece of leadership advice that you've ever received, do you think?
That you need to understand how your people tick.
Yep.
I think we've touched on it already in this episode. You don't achieve anything without them. Your workforce, particularly in professional services, is everything. Understand what it is that makes your people tick, so that they can succeed, and you can reach that end goal.
Sage advice. What about mistakes? Because you learn, my personally speaking for myself, you learn a lot more from the mistakes you make along the way sometimes than the wins you have. Can you think of a kind of a real defining kind of leadership mistake you've made and it really helped you sort of unearth a progression?
I think it was a little bit consistent with what I've mentioned already. Is when you're a professional and you're trying to be the best at what you do, and particularly in a profession like the law, which can be hard and fast. It's not understanding that none of that happens without your people. If your people don't succeed, you're not going succeed. That sometimes takes some failures along the way, and failing to understand that everybody works differently and everybody needs something different to be able to perform at their best. So that's something that I learned over time.
Brilliant. If you could give the apprentice, Aaron, a bit of advice from everything you've learned in your career, the people you've met, the relationships you've built up, the experiences you've had, what would be the piece of advice you'd give yourself, the young version of yourself?
I think it's think big.
Yeah.
Yeah, I think that's what I've learned from my pretty unique career. I had a couple of decades as a federal prosecutor doing a particular job, and you can start to think that you might have done fairly well at that, but that's your thing, and that's what you're good at. And I've been fortunate to have a couple of different roles since then, and loved every minute of it. And I'd like to go back and tell myself, think big. If you want to do it, you'll succeed. Don't. Everybody has doubts from time to time, and I think that can be a healthy thing. But understand, and I know it sounds a little bit cliched, but if you want to do it, you'll make it happen. So think big.
Brilliant, love it. All right, look, we've had an awesome conversation. Thanks again, Aaron, for coming on the Art of Safety Leadership podcast. I think it's been a great episode. There's going to be some real gold nuggets out there. I think a truly unique perspective on the industry that most people out there wouldn't necessarily have. So thank you for the candor and sharing a lot of experiences and wisdom and things that you've been through, experiences you've been through. I think it's been a great conversation. You mentioned some of the services you're currently providing through where you're working now. If people sort of thought actually that someone would really be keen to talk to and engage with a little bit further, how would they track you down and find you?
Just look up our firm, McDonald's Law. You'll find us there, or contact me via LinkedIn.
Brilliant. There you go, folks. Aaron Guilfoyle, what an awesome episode it's been, and look forward to seeing what comes next in that awesome career.
My pleasure, Nathan. Thanks very much for having me on.
Cheers.